Good evening. Oh, there we are. Super teeny. Hi.
I fixed it.
Did it. I am Bob Mata. This is Defense Diaries. And as always, I am joined by my beautiful and brilliant co-host, Allie. What's up, girl?
Hey, babe. Hey, all.
So tonight we are continuing our coverage here on December 17th, D-Day. The appellate brief of Richard Allen will be filed at some point tonight. When that happens, we don't know yet.
We know no later than 11:59.
That's right. And we do not know when it will be made available to us, the public, tomorrow, hopefully tomorrow at some point. But what we thought would be a good idea tonight, in anticipation of that brief coming down, is that we thought it would be good to do a kind of an appeals 101 type course for all those people that are interested in that type of thing. Both our guest tonight, who is the esteemed Michael Osbrook, habeas attorney extraordinaire, brilliant mind. I'm going to be sandwiched between two big brains tonight, which is good because I developed a horrific cough.
But so who better to go over what is required by an Indiana appeal than Michael Osbrook? So let's bring him on.
Wow, you just jumped into my intro, cut me off, and I feel like I should go in the corner now. What's up, Michael?
You're muted.
You're muted. Your picture looks good, though. Hold on. There you go.
I don't know. You're a big brain sandwich now.
Yeah, I mean, I'm the meat.
But what we're going to start with is, and this is my understanding, we're going to start with what the issues that the appellate lawyers have given us a window into what they are going to be discussing. So,
right, and then we're going to back it up. Then we're going to back it up, and I'm going to explain some nuts and bolts terms regarding appeals. Allie's just assuming you all know everything about it.
No, I'm with it. And then we're going to come back after that, and we're going to give you that 101, what to expect in an appellate brief, what the brief is limited to.
It was quite Allie has a lot of faith in y'all. I have to give it to her. She's like,
So does Michael. We're both like, we're going to do
what?
I
was like, both of you guys are just assuming that everybody knows how fucking appeals work, and that's just not factual. All right, so I was trying to advocate for the people. All right. So do you have the document?
I do. I have it up, and then we'll go right to the issues that they have put out, and we'll ask Michael to chime in on what the burden is on some of those before we get to our nuts and bolts. So let's do that.
It sounds like you're getting into nuts and bolts before we get
I mean, I think this is the way we should do it. Personally.
Okay. All right. And if I find that it's going a little clunky, then I'll intervene.
All right. You can do that.
Yeah, I will.
So this was what they filed with their belated motion for permission to file oversized appellate brief. And in that, they're explaining to the court, hey, here's why we need more words. And here
make it a little bigger, please.
Yep, and here are some of the issues that we are going to discuss. So it says, counsel has identified at least 10 possible issues for appeal, 9 of which involve federal and Indiana constitutional claims. These claims are broken into 5 different categories. So 1, the right to present a defense, including alternative explanations of the scene and other suspects, and impeachment of the quality of the investigation. So just starting there, that has a lot involved. That's like it's everything, rolled into one. Their ability to put on uh third party suspects, their ability to challenge the quality of the investigation and explain the crime scene, which would go to them saying that they think it looked like, you know, I don't want to call it a, what is it, babe?
Ritual, odinistic
Like,
ritual.
right.
You don't want
Ritualistic in whatever sense. It still had ritualistic, um, you know, properties. So with that one, Michael, the right to present a defense, can you explain how, because I'm assuming the burden could be different when we're talking about one like due process and the as far as the right to present a defense, but doesn't it also involve evidentiary issues that the judge made errors in law that don't necessarily, that you can come at it both ways from a due process standpoint constitutionally, and then an abuse of an abuse of discretion for an evidentiary reason.
Yeah, so it's going to actually work the reverse. That normally you would argue the evidentiary error first, and then, I think you all probably agree that lawyering would not exist without the phrase "even if."
Right.
So then you'd say, even if the judge did not abuse her discretion in admitting this evidence under the evidence rules, or not admitting this evidence under the evidence rules, there was a constitutional right to present a defense. And in a very narrow series of cases, the Constitution can trump the evidence rules. The leading cases on that are Chambers v. Mississippi and Holmes v. South Carolina. And we have a case out of Indiana. So there was a video, it's Kupch, it was a capital case. And there was a video of and by the time the case got to trial, it was a video interview of a very young girl saying that she saw Kupch, I think it was, coming out of his house at such and such a time, which, if believed, meant he couldn't have possibly committed the crime. The problem is that by the time the thing got to trial, not only could the girl not remember anything about the event, she couldn't remember the video of it and thereby authenticate it. And say, oh yeah, that didn't refresh her recollection. I mean, it just, yeah, that's me, but I don't remember anything about it. So the video itself is hearsay. It wasn't admitted, but the Seventh Circuit got around to saying
just the straight up basics. What is an appeal? So an appeal is a review of potential legal errors made during the trial court proceedings and can include the pretrial phase as well. And there's an examination of whether the trial court correctly applied the law. There's a review of the record, the transcripts, the exhibits, motions, and orders from the trial court judge. And then there's a request for a higher court to determine if errors warrant reversal, modification, or a new trial. That's the basics of an appeal. Okay, so if you guys it's nothing like a trial at all. It's completely
or a post-conviction petition where you can go outside of the record. So in the appeal, you're limited to what is in the record. Now, in this case, we have a very expansive record because they put, I think, almost everything that was excluded into the record at some point. So that allows those issues to be considered, even though they weren't in the trial portion of the record. It's still part of the, like Bob said, your pretrial, everything is part of the trial record, everything that happened at the trial level. So it all gets to be considered.
Okay, so that's what an appeal is. What it isn't, what it is not, is it's not a new trial. There will be no new witnesses. There's no new evidence. There's no new testimony. Okay, they are not reweighing the evidence. The appellate court won't second guess the jury's credibility determinations. They just won't do that. It's not a do-over. You're stuck with the record that was made at trial, which is what Michael was talking about. If they didn't preserve issues, which got me all nervous right away. But you know, if that turns out, when we get the brief and we see things are missing, that means that it wasn't preserved. So when Michael was talking about whether or not certain things were preserved and he's not sure if they were, that gives me an icky feeling in my stomach because I fear that he might be right. And it's not automatic. Just because you disagree with the verdict doesn't mean that you win on appeal. Okay, so just be very clear about that. Okay. Now, Michael, in terms of the state of Indiana, how many judges sit on the appellate court? Do you know?
So there are 15 regular judges. I'm not sure how many senior judges there are at the moment. I don't imagine the senior judge is going to be appointed to this panel, and I'm not sure what the process is. I understand that I think I understood from Kara Winicky that one of the judges is out, can't sit on the case because of some relationship to the case that I don't know about. So we're down to 14, and there's a random selection process. And so 3 judges from the remaining 14. Now maybe they'll add a senior judge to make it 15 to pick it from. I don't know.
God, that was great information. Thank you. That's such a great baseline for people to know. So in terms of appeals, assuming that it's been timely filed, the notice of appeal has been timely filed, must Indiana Court of Appeals accept all appeals?
Well, except they have to decide them all. Yeah. I mean,
they have to accept if it's been timely filed. I just want to have people understand that like there's no set of circumstances in this situation wherein they're not going to accept Richard Allen's appellate brief.
Or I guess consider it and review it and rule on it is what Bob's saying.
Yeah,
sometimes
and I've certainly seen on social media various people saying, "Oh, I hope they accept his appeal."
Right.
Yeah.
That's why I'm asking these questions. Like I obviously understand it. I'm trying to avoid when we get the brief tomorrow from everybody asking all these kind of like baseline questions. So that was kind of the point of doing this tonight. We're going to give some very bare bones, rudimentary background on what the appellate process is, and you guys are doing a great job here.
The Court of Appeals cannot look at the brief tomorrow or the next day, over the next few days, and say, no, we don't think so. We're done here.
Right.
Okay. So and if you've been following the case at all, you kind of understand how the process works. There's a notice of appeal that was filed, right? And then from that point forward, what goes on, Michael? So they get the notice of appeal, and then let's just briefly go through what happened leading up to this brief getting filed tonight.
Before we get to that, babe, I just wanted to touch on because you went on what it is, what it's not. So one of the things I do want to talk about is something that's special in Indiana. Now, although ineffective assistance occasionally lends itself to resolution on direct appeal, which is what this is called, your very first appeal after trial, it's called the direct appeal. In Indiana, you have a Sixth Amendment. Your Sixth Amendment claim of ineffectiveness can be brought for the first time in a post-conviction petition. But if they raise it on direct appeal, they're not allowed to raise it in a post-conviction petition. So considering that just as a real life way of seeing things, do lawyers raise ineffective assistance at the trial, at the direct appeal?
They do not, and the rule is really the same in federal court as well. And I've listened. Actually, I listened to an oral argument not that long ago where an appointed lawyer had brought up ineffective assistance in a direct appeal, and she basically had 3 judges screaming at her to withdraw the claim.
Well, in Illinois, if it is apparent on the record, you have to raise it. So if it's something that is apparent on the record, you have to raise it. And if you don't, it's deemed waived on appeal, where that's not an issue in.
I mean, I can imagine the circumstance, and I don't want to get too far into the weeds about ineffective assistance. I guarantee you, ineffective assistance is not going to be in Stacy and Mark's brief. It's just not.
Yeah, and we didn't see any mention of that in the kind of the 5 general areas that they said that the errors would fall within.
And I raise that just to say it doesn't mean that there's not a potential ineffective assistance of counsel claim. It's just that based on Indiana law, lawyers wait for that until a post-conviction petition when it can be better flushed out using things outside of the record. And as Michael's saying, as a practical matter, they just don't do it in the direct appeal.
Well, and I'm not sure how it works in Illinois, but I mean, if it's apparent on the face of the record, the problem I see is it's never apparent on the face of the record, because you can't judge ineffective assistance in most instances without the testimony of the trial lawyers, because
otherwise it's just strategy.
Yeah, I mean, even if something didn't work out, it might have been a reasonable strategy decision. And
I agree. I wish we had a clear-cut rule like that, but I've seen it where they say, well, that they could have raised on the record, so it's waived. And then you've got to fight tooth and nail on appeals from your post-conviction petition for them to say it wasn't waived. But
okay, all right. So the notice of appeal is filed, and at that point, then there's going to be a preparation of the record. If you follow the case at all, we know that we had some issues with that. The court ultimately had to tell Judge and her Gull and her clerk there to get what they needed in terms of the exhibits that were attached to the Franks, that for whatever reason were not getting turned over to Rick's appellate counsel. So that got done. They filed a new basically they filed and said, look, we got the record where it needs to be. And they then gave Stacy, Uliana, and Mark Lehman another 30 days from that date to get their brief filed. Okay, so then we saw the motions come in wherein they asked for a little extra time. They needed that 10 extra days. They also had a request for 10,000 extra words as well. Both of those were granted, which leads us up to today's date. So, Michael, after the appellant's brief is filed, which will be before 11:59 tonight, okay, what happens next?
Next thing is a brief from the Attorney General's office, and
would you expect an extension request is the next thing?
Oh, I would expect a couple at least. I mean, we're talking about so the appendix, the brief has to be filed together with an appendix that's separate. It's a little different in federal court where you have a short appendix, which is actually included in the brief, but you file a separate appendix, which includes what? It includes all the papers filed in the case, pre-trial and post-trial. All the actually, the appendix is also, the appendix probably won't have the papers filed that are associated with hearings. They'll be there'll be exhibits and transcripts, but I mean, just the Franks memo. I mean, what was that? I mean, the exhibits to that had
voluminous,
1,000 pages or something.
Yeah, it was big. It was big.
So there's a multi-volume, and the appendices have to be limited to 250 pages. So there are going to be multiple volumes of that. Normally with something that big, I would have gotten the appendix filed early, but People do it differently. I would only want to be messing with the brief tonight.
Yeah. Doing all the spell checking, all the make sure all the I's are dotted, the T's are crossed. Because that's a pretty panic inducing last night when you're trying to get that brief completed. And by way of the fact that they went to the court, they said, look, we need 10 extra days. They're going to use every minute of it most likely in order to get that thing all tied up. So that's, I mean, we've been there like panic filing at 11:59, like hairs falling out of our head, screaming. Say it's like a nightmare scenario. Something inevitably goes wrong with the electronic filing. It's like it's just a really intense set of circumstances typically.
I
So
really have had some go through at 11:58.
it's like a fucking nightmare. All right, so Michael, and the reason we asked about their request for extensions, so they have 30 days to file their response, but you anticipate that they'll file at least a couple of extensions. So, like, just to give people a loose guess in terms of when we can expect the state's response, we're thinking 90, 120 days, somewhere in that area.
I don't think they'll look. They may ask for as much as 120. I don't foresee it going beyond 90, and I think the state might get it in 60.
Okay. All right, good. And then, so once that is filed, now in Illinois, we have reply briefs. What is the deal in Indiana?
Oh yeah, there are reply briefs.
And how much time do you have for that?
Oh Lordy. Time for filing. I just happen to have the rules here. So 15 days after the reply, after the answer briefs, state's briefs filed, you have to file a reply. I guess there's going to, my bet is there will be a 15-day extension on that.
I was just going to say, yeah.
And on a reply brief, what are you doing? So you've received the response from the state, and what are you doing in your reply brief? So you're not raising new issues, right?
No, you're explaining why the state's wrong.
You're the lawyer, you're reading the reply brief, and you're like, wow, I just thought of the most amazing argument, the most amazing issue. I want that wins the day. Too bad, too sad, right, Michael? If you didn't raise it in your initial brief, you can't raise it in your reply brief. Or is there a process by which you could say, hey, court, will you let me raise a new issue now?
No, but you could try and sneak it in. And I have certainly seen cases where the Indiana Court of Appeals has in fact considered issues raised for the first time in a reply brief. It's not supposed to happen, but
the courts always leave themselves that leeway to say the rule says this, but as the court, we have discretion to consider it, even if waived, even if this, even if that. And you're saying occasionally that does happen.
Well, so I actually won a habeas case where the Court of Appeals had one put over on them. It's a very narrow difference, but the lawyer who had the post-conviction case in state court switched from the failure to put on an alibi defense, and in the reply brief made it failure to investigate an alibi defense. And it was a critical difference. The Court of Appeals addressed the failure to investigate, which hadn't been raised. So they decided that on the merits. So it was all teed up for federal court, and we got a new trial.
Nice. So basically what we're saying is that whatever the defense raises in their original filing, it's the issues are limited to what they raise. So once the state responds, then you are replying to what they have, the holes that they have tried to make, the attacks that they have tried to set forth and say, for these reasons, the defense's argument should fail, and you counter those, each and every one of those. And can you tell everybody what the rule is in Indiana if you just kind of gloss over it, or you raise an issue either in the original brief or in your reply brief, but you don't fully flesh it out with all the supporting law? Will the court consider that?
Yeah, you don't have to have all the supporting law. So there's, and the Court of Appeals is, what can I say, arbitrary and capricious with the way they
Right.
apply the rule. They can say an argument's waived for the failure to make cogent argument. But that should be, in most cases, a pretty low standard. I, of course, have seen, I mean, including one case should be enough. One supporting case means you've made cogent argument. Now, maybe there are other cases going the other way or something. And
I mean, I've seen in Illinois where actually I had an appeal once where I just incorporated, I laid all the law out in one ineffective claim. And then in the next one, I just said, see here. And the court said that I didn't put enough supporting argument in it, and it was waived. So they say, hey, you didn't flesh this out enough. You didn't include enough law. Michael's saying one case should be enough. But sometimes they say, well, this reference to this one case didn't fully flesh it out, and you're screwed. But Michael's also saying they're capricious and arbitrary. If they want to consider it, they'll consider it anyway. If they really just don't want to, they may lean on a rule that really shouldn't apply.
I mean, it won't happen in this case, but I had a case where there was an issue. I raised the Indiana right to have a 12-person jury, even in misdemeanors. I mean, I had support from the constitutional debates. The Court of Appeals just dropped a footnote saying, well, there's no federal right to 12-person juries in misdemeanor cases. End of story. It didn't address the Indiana Constitution at all. They can just ignore issues if they want. They won't do that in this case.
Right.
But
and Bob's left.
I mean, people.
No, I didn't leave. All right.
The Indiana Court of Appeals is absolutely the Wild West.
Scary.
All right. So the court is fully briefed. Okay, so that meaning that the appellant brief is filed, the response is filed. If they're going to file a reply, they file that. At that point, it's then discretionary as to whether or not the court wants to hear oral argument. Correct?
Yeah, and the parties can ask for it. I don't imagine the state will ask for it, but I think Stacey and Mark will ask for it. Oral argument.
How much time do they get if it's granted?
Well, that's kind of up to the court. Typically, the Supreme Court's typically 20 minutes, except for death penalty cases, in which case it's half an.
I think, or was that what you were asking, babe, or would be how long until the hearing's set?
No, how long do they get to argue?
Oh,
once they're in.
Probably get 20 minutes.
Right,
and they might, in this case, there are enough issues. They might get 30. They might get 40. And the other thing is, they might get 20, and the judges sit there and give both sides more time.
And Allison's question is excellent as well. How long after the reply brief, if that is filed, will they decide whether or not they want an oral argument? Will they basically decide that they want that closer to when they're getting ready to put their decision out there, or is that earlier in the process in terms of your experience?
So in the cases I've done, not as a deputy attorney general, I haven't had oral argument in the Court of Appeals. They don't usually come out with decisions that quickly after oral argument. Sometimes they do. My guess is it's going to be a while before we hear about oral argument or not, because they're going to have to look at the record and the briefs, and they're going to be long, and they're going to.
And is the courtroom open to the public?
Yeah.
Okay.
Yeah.
This is
And
all great intel. This is such good
it's not only open to the public. Who knows? They might do it as what we call a road show. I mean, they go to high schools around the state and have oral arguments, I mean, in public, not just in the Court of Appeals courtroom.
Yeah,
And do they
that
make
happened
the
for Barton McNeil and Jamie Snow. I went to Illinois State. They had both of those oral arguments take place at ISU, and it was great. It was an amazing experience. It was amazing to see all the young college students in there. It was a packed house, and it was really a neat experience. I was happy to see it.
And do they in Illinois, we get the oral, always the audio from any appeal that you want to listen to. Do they make the audio and/or the audio and video available in Indiana for every case?
Pretty much. I mean, they have the video set up in the Court of Appeals courtroom too, and they take video on the road.
And do you think, again, in your experience, are most decisions based on the papers alone? Like, meaning that more often than not, they're not going to be having oral argument?
Yeah, oral argument in the Court of Appeals is extremely rare.
Okay, good.
And
I
do you
mean, when I
know
say, yeah,
what do you think that they base that on? Sometimes I think if it's like the judges are disagreeing or they think it's like one of the issues is important enough, what do you think decides whether they want that oral argument?
it might be judges disagreeing. It might be, oh, let's do a road show, and this will be an interesting case for high school students. Or I know when I was clerking on the Indiana Supreme Court, there was an argument at IU Northwest in Gary that the Supreme Court did. Maybe interesting for university students. It could be, it could be the judges are disagreeing, and it could be, if there's an interesting legal issue that even if the judges aren't disagreeing, they want to hear the arguments.
And I want to get into that process of the decision making. So, as you said earlier, ultimately it's going to be a 3-judge panel, correct? That's randomly selected.
Yeah.
Right. And so how do they determine the 3 judges who are selected, who is going to write the opinion?
As the majority, for the majority.
They just decide among themselves. I mean, let's say it's 2-1. My guess is the 2 in the majority decide which between them is going to write the opinion.
So that's interesting. Are you saying that essentially that they will have reached a decision prior to putting pen to paper and say, all right, this is where we're at on it. And then at that point, they'll say, okay, if we have a majority, one of the 2 from the majority will be selected to actually write the opinion?
I wish one of my former students who spent 3 years clerking for the Court of Appeals were here.
That'd be awesome.
But yeah, and I didn't know if they just choose like the whoever has seniority writes it. I guess they just decide amongst themselves which one will write it.
I know. I certainly have. At least I know from this former student of mine, they just decide themselves. And look, I mean, these judges, they're 15 judges, but basically there are so many cases. I mean, it's not just the criminal cases. They've got the civil cases, plus all the motion stuff. They've got, if you don't count the senior judges, basically every judge has to be doing 2 opinions a week.
Wow.
About 100. It's about 100 opinions per judge per year. Now they have 3 clerks, and the clerks can write some of the run-of-the-mill stuff. I mean, it was a long time ago, but the cases are still the same. I mean, there were cases where I wrote, brief for the Attorney General's office in a criminal appeal that was, 4 pages.
Okay. And as far as, just so people have an understanding, you can have a split. It does not have to be unanimous. So out of the 3, it can be either unanimous, and we're talking about if no matter which way they come down, or a 2-1 split, correct?
Well, it can be a 2-1 split. I mean, yeah, on the judgment. So the judgment's going to be whether to affirm or reverse the convictions.
Correct.
There's going to be a 2-1 split on that. There may be all kinds of crazy splits on the
Reasoning.
different issues.
Right. So when you get that happen, where the judges all agree that the end result should be the same, but you can have 2 judges who agree on this issue and a different 2 judges that agree on that issue, and then you get a bunch of concurring opinions from different judges on different issues within the same opinion. So when we say concurring, that means, well, I agree with what the majority of the judges have said here, but for a completely different reason. And a lot of times, if it's important enough, they'll write it out. Otherwise, you just see concurring.
So that would be concurring in the judgment. If it's I agree with the result, but I disagree with this other stuff, that would be, I mean, that might be labeled a dissenting opinion. It might be concurring. If it were the U.S. Supreme Court, it would be concurring in the judgment. Yeah, I'm not sure how.
And then for dissenting, you mean, so that's if 2 people say this person should get a new trial and one person says no, he shouldn't. That is where we would get your dissenting opinion.
That would be dissenting. Yeah. Yeah.
And but just so people have an understanding, you can have a dissenting opinion, meaning that they're not in agreement, but you get that 2-1 split and say they are in favor of Rick Allen, and they're going to grant him a new trial. They're going to vacate the conviction. That can happen if it's a 2-1, even though you have one of the judges saying, "Nah, I'm not for it." But as long as you have the majority, that's going to happen in terms of what the majority rules.
Right.
Right. Okay. So in terms of a timeline, in your experience, once it's been fully briefed, what is the usual timeline that we can expect to hear some kind of decision?
Well, it's funny. The public defender listserv, people have been complaining recently about how long the Court of Appeals has been taking to decide cases. It used to be known as the rocket docket. It was kind of 6 weeks to 2 months. Now, I wouldn't expect Rick Allen's case to be decided in less than 6.
Wow.
I mean, I just wouldn't. And it may be a lot longer. I mean, people have been saying pretty simple opinions have been taking a year.
All right.
So babe, before we get to the issues in this, I have that one.
I got a couple more questions that I'm asking.
All right, and then let me know if you need me to or don't need me anymore to pull up the brief.
So say for instance they come back against Rick Allen, what are the post decision options as far as the appellate court?
So you can ask for rehearing in the Court of Appeals, and I expect that they would ask for rehearing. Now, there are reasons. I guess I can let out this tidbit.
Let it out, Michael. Let it all out.
So there have certainly been cases where the Court of Appeals has made just a whopper of a mistake. And somebody's been asking me about the case, and I'm in on the case early enough, setting it up for habeas. They made a whopper of a mistake. I don't want them to fix it.
Right.
They made such a mistake about the Constitution. No reasonable judge would have said that. That's the standard for federal habeas relief. Just let me get this to federal court, please.
Right, because if they ask to reconsider and they put in all the reasons why, then the court can fix some of their, even if they don't change their answer, they can reformulate it to address those issues that you're saying, well, if at this point, this is like completely the whopper of a mistake. But if they get a chance to kind of tweak it, they might fix some of that. Is that what you're concerned?
Yeah, I mean, if they take a constitution, look, I'm looking at the case right now where the Indiana Court of Appeals, it actually involves the right to present a defense. They say, yeah, might have violated his right to present a defense, and then they don't use Chapman, the constitutional thing. They use the evidentiary standard for prejudice.
Which was,
I mean,
now, for those of you that remember, I know some of you might have come in late, but this is exactly what Michael and I were talking about early on, that you raise an issue and you come at it two ways. One, the judge made she made a wrong decision about whether evidence should get in. And then if not, two, well, this is a constitutional issue. So Michael's saying you had this ruling where the judge is agreeing that it's a constitutional issue, but relying on the prejudice standard. Is that?
yeah, the prejudice standard from, it didn't prejudice his substantial rights. Instead of under Chapman, when there's a constitutional error, it's up to the state to prove the error was harmless beyond a reasonable doubt. So that means that because the state court applied the wrong standard, I get the federal courts to look at the whole thing all over again.
But could the result be, hey, lower state court, you used the wrong standard, go back to the state court and have them use?
Nope.
Oh.
Nope. It's either give the guy a new trial or release him.
Well, that's a damn good reason not to let them fix it.
So that was a situation wherein the court has affirmed, the lower court. Now, in the event that it's reversed and remanded, meaning that they're saying, okay,
wait, but he didn't actually finish what happens here.
So there's rehearing, and that's obviously going to be Mark and Stacy's call if they lose in the original.
I know. I wish Allison wouldn't have interrupted me, because I was going to ask, if it's reversed and remanded, can the state also, can they ask for a rehearing?
Oh, absolutely.
Okay. Allison's laughing, but people
well,
don't
I
know
just
the
wanted
answer.
him to finish what the steps are for if it's affirmed before we got to, but I hear you.
Yeah, no, either side can ask for rehearing, and frankly, if the state loses in the Court of Appeals, I think they will ask for rehearing.
Which is exactly what I wanted to know. If Rick ends up winning on the appeal, so you think that the state will ask for a rehearing?
Yeah, I think they will. For two reasons. One, it drags things out. I mean, they
have a lot to do to get ready for a retrial.
And
but it also gives them, they get to sharpen their sword for their transfer petition to the Indiana Supreme Court. And I guarantee you, whichever side loses, it's going to the Indiana Supreme Court.
Right. So that was my next question. And how long? So first of all, in terms of the motion for a rehearing, which is essentially, like Allison called it, a motion to reconsider, right? How often is the court reversing course? Because, in our experience, it's pretty rare when you're going in and say, hey, judge, you screwed up here. You misapplied the law. We want you to fix it. How often does that end up actually working?
I would say almost never. I mean, sometimes they'll fix it. Sometimes somebody will point out that they did something wrong, and they'll come back and say, well, they asked for rehearing, so we got this wrong. Yeah, maybe we did, but it comes out the same way anyway. So I mean, I had a case written by a chief judge then of the Court of Appeals, relied on a U.S. Supreme Court case that the U.S. Supreme Court itself had overruled. I filed a petition for rehearing. The Attorney General agreed with me, and the Court of Appeals did nothing.
Wow. That's all right. So
outside of the motion for rehearing, either side that is unhappy can then appeal the decision to the Indiana Supreme Court.
So what it is, so petitions to transfer are a little different from the way most courts operate. They're called petitions to transfer. So in most courts, let's take the U.S. Supreme Court. somebody loses in a circuit court of appeals, and they go to the Supreme Court and they ask the Supreme Court to take the case, that's what a cert petition is, and then to reverse the decision of the Court of Appeals, right? That's not what a petition to transfer is. A petition to transfer is a request for the Supreme Court to take the appeal as if it had been filed in the Supreme Court to start with. They're not reviewing the decision of the Court of Appeals. They're deciding the appeal themselves. If they grant transfer under the rules, the Court of Appeals decision is automatically vacated.
And when is that a viable option? Because that's shocking to me.
Well, when is transfer a viable option?
Or what is the standard that would warrant them saying, I'm going to take this as a transfer instead of as an appeal from the lower?
There is no such thing as an appeal from the lower court. It's only transferred to the Indiana Supreme Court.
Oh, so they don't even review what the appellate court did to say if they did it right or did it wrong. They just start their own review.
Well, one of the reasons they'll take a case is they will say the Court of Appeals got it wrong. I mean, they'll talk about the Court of Appeals decision. They won't pretend that and if you go to Appellate Rule 2057, there's a whole series of things that they say warrant transfer, a conflict in the Court of Appeals decision. So, and it happens pretty often that there are splits between panels in the Court of Appeals. I mean, I've got a case in the Seventh Circuit, two co-defendants, two different panels of the Court of Appeals. They came out with the same result, but one said this is a critical stage, and the other said it wasn't. In the same case. I mean, co-defendants who were there at the same time, neither had a lawyer.
Wow.
And you'd think that would be, however it comes out, you would think that would be the kind of thing the Supreme Court would take just to clean it up, right?
Right.
They didn't. So conflicts in the Court of Appeals, conflict with the Supreme Court doesn't
delineate of whether that opinion conflicts with the Supreme Court or if there's some sort of conflicting opinions out of the Supreme Court.
Well, I think they say, and two, conflict with the Supreme Court decision, they mean conflict with an Indiana Supreme Court decision, because the next one is a conflict with a federal appellate decision. Then there's an undecided question of law, and then there's precedents in need of reconsideration. 6 is a significant departure from law or practice. I mean, I can think of one already that would be suitable for significant departure from law or practice, and that was the refusal to let Andy Baldwin impeach Brad Weber, because what he did, as Andrea Burkhart pointed out, was classic impeachment. I mean, and she said, "Oh, you did it wrong," blah blah, and I mean, that's a significant departure from law or practice. If the Court of Appeals says that's fine,
then the Supreme Court will accept the transfer.
Well, that's a reason,
or could,
it might warrant transfer. I'm not saying it's
right.
Not because if one of these things happens, that doesn't mean the Supreme
they'll
Court
do it. It just means they can do it.
Yeah, and typically what the Supreme Court does, when sometimes they just grant transfer and then order oral argument, but very often in the last, I don't know, decade or so, maybe even longer, Kara would know the time frame. Supreme Court's been having oral argument before they decide whether to grant transfer or not.
Wow, interesting. And so what is the acceptance rate typically on a petition to transfer? Is it pretty low?
Oh yeah, it's pretty low.
And if the so that ends your course for relief in the state court, and does
It ends a direct appeal.
in state court. But can't you take that to the federal level?
You can, but it would be a really bad idea. I mean, because you only get one federal. Oh, no, you could, no. Oh, when you say take it to the federal level, yeah, once you've gone to the Indiana Supreme Court, you can go to the U.S. Supreme Court.
On your direct appeal without
Yeah,
waiving any of your later federal rights.
Right. You can do a cert petition to the U.S. Supreme Court asking them to take the case on a federal question.
And can the state do that as well?
Absolutely. Yeah. I mean, it hasn't been out of, and if the state were to do that, and they might, again, also just for the purpose of delay, if they lose.
All right. At this point, what I'd like you to do, Allie, can you pull up that appellate brief, please?
So what we have is an appellate brief that was filed by the same appellate attorneys representing Richard Allen in another high-profile case, just to let you see what
Dave can.
Yes, what an appellate brief is made of. And they're all going to follow the same format. So you want me to just go through it, babe?
Yep.
So you start with the table of authorities, and that's the cases that you're using to rely on. So this is their table of authorities here. Every case that they cite within this brief. Then you do a statement of the issues. Now, in this case, there was one issue that was very simple. So, whether the trial court abused its discretion by denying Cram's petition for a special prosecutor, where the prosecutor negotiated a contract to write a book about a case, received in advance, and subsequently misrepresented the facts of the negotiations to the trial. Now, Michael, in this case, the statement of issues, it's supposed to be brief. Is that fair to say?
Yeah, I mean, it depends. So this is what's known as sort of a short form statement of the issues. You can do what's called a long form statement of the issues, and I typically do that because it's an opportunity in a way to make argument. I mean, you can set up the facts. I mean, they kind of get all the facts in there.
Right.
One of the things that's sort of infuriating to me about the Indiana Court of Appeals, and you'll see it in opinion after opinion, we restate the issues as. Please don't restate my issues for me. I took a lot of time stating them the way I intended to state them.
Right.
And that's a thing. Like preparing your statement of your issues in terms of, like, if you have multiple issues, you really want to hone in and have that thing as tight as humanly possible. Because again, remember, you're up against a word limit here, right? So like appeals and briefs are not the places where you want to be overly verbose, because you have very limited space in terms of being able to argue everything that you need to argue when you get to the argument. So in terms of framing the issues that you have, you need those to be very, very tightly written in terms of laying out exactly what the issue is in the most concise way possible, which is hard to do. I mean, it's a difficult chore, and it's one of those things that I think is kind of overlooked in terms of, and lay people probably when they're looking at it will just read through it and not realize how much work went into trying to craft those issues. Cause like, that's really your first salvo to the court. It's going to be the first thing of substance that they're going to look at, and they're going to read through it. So you want it to be impactful. You know what I mean? You want them to be like, all right, this sounds like this could be an issue. You know what I'm saying? So, and then after that, what do you get into?
Statement of the case. Now, the statement of the case is usually, or no, sorry, the statement of the case is I guess I was going to say the statement of facts is where they're kind of summarizing, what happened. So here, they start like on the date and what happened, and how
So
he
the
came.
statement of case in Indiana is pretty much the procedural history. And different courts do it different ways. In Fed court, it's all under statement of the case, and you can set it up facts and procedure however you want. Here, I mean, the actual language for the rule on the actual rule really is about the procedural history. I think it's and so then the statement of facts are so they're going to be the historical facts, and
This will be, you would expect this to be very lengthy in Richard Allen's case, because, correct me if I'm wrong, if you don't put some fact in your statement of facts, you cannot rely on it later in the document.
In Indiana, and actually the courts will do that themselves occasionally. People will put at the end of the facts, other facts will be added as necessary. I haven't seen a brief blown out because a fact wasn't in the statement of the facts but appeared for the first time inside an argument.
And every time that they put a fact, they have to cite to where in the record it is, correct?
Pretty much, yeah. And I will say, if your fact isn't, if your fact appears for the first time down in the argument, there's a thing that comes between the statement of the facts and the argument, and that's the summary of the argument. And it's going to be hard to do the summary if you have an important fact you've left out. It's going to be hard to do the summary of the argument using a fact you haven't mentioned in the statement of the facts.
So the statement of facts is not just someone gets to kind of just tell their version of events and their story and just kind of put it all out there. As you can see here, every sentence is followed by a citation. Every sentence is followed by a citation. If you can't cite to it, you can't put it in as a fact. So,
all right, let me, and I'm sorry to do this, but I wanted to jump back. You guys jumped into the statement of facts a little bit ahead of time. Now, Michael, in this case, it's interesting because the procedural history in this case is very interesting in terms of, a lot of times in the beginning of the case, there could be things that may be significant issues. Here in Richard Allen's case, we have things that occurred that are definitely big issues. Would they raise those first in the procedural history? And obviously, I'm talking about the safekeeping order that was put into place while Rick Allen wasn't represented at all in any capacity when that initially took place. Would you place that in your statement of the case, or would you kind of wait
and put it in statement of facts?
And put that in the statement of facts?
You could do either. I think what I'd be tempted to do would be say something like, actually do a pretty bare bones recitation, and a bare bones recitation is going to take a while, of the procedural history, adding that the related facts to that will appear in the statement of facts below.
Okay.
That's right. Off the top of my head, that's how I think I would do it.
Okay. All right.
So, and as you can see here, that they're in their statement of the case, they're talking about, when the state charged them, when the first conviction was, how many trials there were, when the Indiana Supreme Court denied hearing. So that's what Michael's talking about, the procedural history. Then they filed something, then this happened, then that happened. So that's what's happening there. So we went over your statement of facts, how that's going to be very detailed. It's going to go over everything, and everything needs to be cited. Now, in your summary of the argument, that is a place where you can just kind of talk without citing a case, without citing um, a specific document. You can just kind of give them a little introduction to your points. How would you best describe the summary of the argument and the significance and importance of it, Michael?
Well, a lot of judges that I've heard have said the first thing they look at is the summary of the argument. Not the issues, but the summary of the argument.
Interesting.
I think the summary of the argument is really important. It almost always, it's funny, there's kind of a seesaw when I'm writing between the argument and the summary of the argument, because I write the summary of the argument, then I go do write a sort of draft summary, then I go do the argument, say, oh, okay, well, now I need to redo the summary of the argument.
And the reason that that's important to us as lawyers is because, and like Michael's saying, sometimes justices, they go right to the summary because, as you'll see, as we go into this, once you're in the argument, there's a lot of technical ways that you have to line things up. So you don't get to your point right away very easily, and you don't get to connect things until sort of later sometimes. So in the summary of the argument, you can give them that initial introduction so they know what to expect, they know what's coming, and then when they're reading the argument, they already kind of understand why they're reading something. Where without the summary of an argument, they might not know where it's going because you have to follow a certain procedure, when you're doing the argument. So then in the argument, explain how the argument works and why we have this thing that's bolded right here and the significance of that.
So arguments have what are called point headings. And this one isn't numbered because there's only one argument. There will be numbered. I mean, I don't know how many separate arguments Mark and Stacy are going to make, but they're going to be numbered 1 through 9 or 10 or however many.
Right.
And each point heading basically is the thesis for that issue.
So once you lay it out here, like here, the trial court abused its discretion in denying Cam's petition for special prosecutor, they're going to get into the law, like what the standard is for a court to review such a thing, what they're going to be looking at. So they're getting into all of that before the court even necessarily hears some of the, the application of that. So
can you go back to the point heading for a second?
Sure.
Now, I don't remember exactly how they put the statement of the issue, but they added a few facts to it. But look at the point heading. To change it to a statement of the issue, you just add whether the trial court abused its discretion in denying Cam's petition for a special prosecutor. I mean,
right.
And like, here's where I want to pause you guys and get into a little more, but so you're starting to talk about standards of review, which is a very important thing that I want you guys to explain to the people. So in that argument section, there's always going to be typically a concise statement of the applicable standard of review, correct?
Yeah. I mean, this only has one issue. So, what I typically do is, so for habeas things, it's a single standard of review by the time you get to the 7th. So it's not really a problem with briefs in the state courts. If this were heading 1A would be standard of review. This court reviews a constitutional issue de novo.
And see, that's what they did here. They started with the appellate court reviews this for an abuse of discretion, and then they defined abuse of discretion.
And I think for the audience, an abuse of discretion really means one of two things. Well, three things. The judge really got the law wrong. The judge really got the facts wrong, or the judge did just something really crazy. But it's usually really gets the law wrong, or really gets the facts wrong.
Right.
So
And
the way that I kind of think of standard reviews and like so a de novo review, which basically translates from Latin to fresh look, right? So that is, how would you guys define that for the people? Because I would consider that to be, like, in terms of difficulty levels, that would probably be the easiest difficulty level in terms of the different standards of review. How would you guys define a de novo review, and what applies to a de novo review?
So, de novo review would be, so they do de novo review of, for instance, so we've talked already about the right to present a defense, right? So given the pretty much undisputed facts, let's assume the issue of, the right to present a defense was preserved. The Court of Appeals owes no deference to Gall's decision about that.
right. And I figure, babe, that when we switch back to those points, we can talk about the standard review for each of those. That's kind of
Wait, which points?
the 9, when we get back to the motion.
Oh, yeah. Like, I think we just kind of go through and just talk about the standards of review, because it's like, if you don't understand the standard of review and we keep throwing the terms out and people don't know what the fuck it means, it has zero impact on people. So I think, and what I'd like to do is just kind of go through, and we got de novo. Michael was starting to get into abuse of discretion. You've got clearly erroneous, and let's go through those real quick, and then we'll go back and do it however you want.
Yeah. So an abuse of discretion is, it's the general standard of review for most trial decisions, and it basically means that we might disagree, but it's a debatable thing, and it wasn't an abuse of discretion. There's nothing legally wrong. There's nothing completely, anyway, factually wrong, and we might have called it differently, but the judge called it this way, and that's not an abuse of discretion.
Right.
And there's substantial deferences given to the trial court with respect to abuse of discretion. Unlike with de novo, they give no deference to the trial court, right? So that's a difference between those standards of review.
At least on the law. I mean,
Right.
if there have been factual findings by the trial court, then those factual findings will be reviewed for clear error, which is kind of like an abuse of discretion. I mean, it's the same. I mean, if a judge has found facts, unless they're really, really wrong, Court of Appeals is going to.
Right.
So
Okay.
I'll give you an example of, where legally, so evidentiary rulings are going to be reviewed for an abuse of discretion. So that's the state evidentiary rulings based on state law. So it's going to be interesting to see if it comes up. Gall at some point says, on the record, and I mean, so one time I think she really opened her mouth when she shouldn't have. She said no nexus because no DNA. That's getting the law wrong.
Right.
That's an abuse of discretion. Now, we can argue about whether that means conviction should be reversed, but that's an abuse of discretion.
And if a court finds an abuse of discretion, is the next step whether that was harmless?
Yeah, but there are different standards for harmlessness. Whether it's so for a ruling on an evidentiary ruling is harmless unless it, and the language is, prejudiced a defendant's substantial rights. I mean, how mushy is that?
Right.
And, you know, all the court has to say is, we don't think it prejudices substantial rights. I mean, there's no test there.
Right.
Right. All right, so let's get through this tonight because I think the application is going to be easier applied when we're in the issues here. So then, what you'll see after you have the issue, right, the court abused discretion, then they're going to say why. Okay, and that's why you've got this like A, B, and C. So here they go through why, how the trial court erred for this reason, and then you've got your A1. So you sort of do that with each issue. So that you can imagine how here it starts to get really, really, really long,
Can you go up to the table of contents real quick?
Yep.
Allie, skip that.
So if you'll see here, the point headings are up here, and actually Justice Moulter has said, so I mentioned that some judges look at the summary of the argument first. What Justice Moulter on the Indiana Supreme Court wants to see is, he wants to be able to look at the table of contents and read the point headings as if they were a summary of the argument. In other words, he wants, so that's basically the outline of the argument.
And this is something lawyers, we all actually spend a lot of time and what's in it. And, so it's not like, oh, I'm just going to kind of summarize this real quick. It's like every word is considered, how to say it, because some justices will use this and be like, you said something different than you even said in your, like that's not even what you captioned this. That's not what your point heading says. And you're trying to get into something completely different. So the words are very important here. But this gives you basically what they're doing. So the trial court abused its discretion in denying that for this reason, and here's 2 reasons why. For B, for this reason, and here's 2 reasons why. And then, it ends up incorporating, a little bit more because it gets into a conflict of interest. But we don't need to get into in too deep there. And then you'll have your conclusion. And that's basically what a brief will look like and what to expect to see here. And you have your footnotes. So let's apply some of this to what we do here. So we started with this first one, the right to present a defense, including alternative explanations of the scene. So remember the state put on evidence that this was a, what did they call it?
An undoing.
An undoing, right? They provided their own explanation for why the scene looked the way it did, and then the judge prevented the defense from putting on evidence of what they believe the scene says and why that the scene speaks to something different than it being Richard Allen. Now, you started to talk earlier about how this is both, you've got your evidentiary issue that the judge should have let this in. It's relevant. It was admissible before you get to the constitutional issues. So, starting with those 2, what different ways will the courts then look at this issue? Let's use like the scene or other suspects for, as an example.
Yeah, so I think the scene's a clearer case. So I think I'm just be repeating what I said earlier. So as a matter of Indiana evidence law, it'll be reviewed for what? An abuse of discretion. Did the judge get the facts or the law wrong? Yeah, I kind of think she did.
And then the harmless error test would apply after that of whether
the prejudice Rick's substantial rights. And it'll be interesting to see whether they go on to take on the constitutional error, because there's a much stricter standard for constitutional error. I mean, if it was a violation not only of state evidence rules, but also of the Sixth Amendment, then the standard is the state has to prove that the burden is on the state to show that the error was harmless beyond a reasonable doubt. Now, we're talking about appellate judges here, right? And they have to do all this stuff in their head. It's all hypothetical.
Yeah, and my takeaway in terms of that particular issue was I've never seen nor heard of any case that I've been a part of or anything that I've ever observed wherein the judge did not allow the defense to posit any kind of theory as to why the crime scene appeared the way that it did. I mean, the way that she shut them down, Michael, was unbelievable. Like she was on high alert, sitting up on her lofty perch and just waiting for Baldwin to slip and say something that would relate to Odinism or that it looked strange in terms of ritualistic, like anything that he would have uttered, she would have been all over him. And I've just never seen that before. I've never seen a case where essentially the defense was foreclosed from discussing what the crime scene looked like at all.
I absolutely. I mean, I wasn't there. I took your description of it and Andrea's description of it, and I it's like, well, why are we having this trial?
Right. I mean, that's what it felt like.
So, and that hopefully you guys understand the difference there is that when you look at the same question from two different legal theories, one whether the judge made the wrong evidentiary ruling, in which case then the defendant has to prove he was prejudiced by it, and he has to show why he was prejudiced by it. Then once you get to if they look at it from a constitutional standpoint and say, all right, this ruling violated his right to present a defense, it violated a constitutional right. Now the state must prove beyond a reasonable doubt that that error did not prejudice him.
And well, the language actually show that it didn't prejudice him because beyond a reasonable doubt, because right, the state can't prove anything at the appellate level. All it can do is argue.
Show.
And no, but I mean, it goes to the point I was trying to make earlier that might not have that the people in the chat, your audience, might not have picked up on, and that is, the judges aren't sitting as jurors, like sifting facts and weighing credibility and stuff, and all they can do is, when they're considering whether an error was harmful enough to require a reversal of a conviction, they just have to play these games in their heads about, well, okay, we got away, didn't get the crime scene explanation in next to whatever the evidence that Rick was bridge guy, which I think was zero, but anyway, the bullet. I mean, they've got to line it up against all this. And by the way, at the end, there's going to be, I'm betting there's going to be a really complicated section, or maybe it isn't complicated. They're just going to say it. Cumulative error. In other words, they got this Sixth Amendment claim wrong. They got this other thing wrong. They got this other thing wrong. These things all together,
right,
require a retrial.
Right. And that's a powerful argument in this case, because it's, I mean, it's essentially a death by 1,000 paper cuts type argument. But I mean, when you look at everything cumulatively, it's incredible. She really cut their legs off from being able to put on any kind of defense, and they simply had to lean into just trying to create doubt, which the fact of the matter is that they had viable defenses here, which she just didn't allow them to use, because it's like, I think people have kind of a general misunderstanding that there's always a defense, because a lot of times there's not. I mean, Allie and I have had plenty of cases where we haven't been able to point the finger at somebody else, where there's not a reasonable explanation, where there's not an alibi, where there is really no other defense, to where we're forced, because of the facts and the way that they exist, we have to lean into trying to create reasonable doubt, and that was not this case at all. I mean, they had substantial facts behind them that they could have presented at trial in the form of an actual defense, which she just didn't allow for. And it was one ruling after another, which cumulatively ended up just cutting their legs off at the knees, and it was, I agree. I think that argument, I'm hoping that it's going to be hefty.
Yeah, we'll see. We'll see what it is. It's going to be.
So when we take this same application to 2 here, the right to present a defense undermining the reliability of Allen's incriminating statements. So now this also deals with both an evidentiary issue, because it's possible that you have a voluntary confession under the law. Voluntary, wasn't coerced technically by the police. It was given by his own words to his family, but it may be unreliable in the sense that it's false or the product of mental illness. Thus, it is relevant what were the circumstances surrounding his making the statements, and specifically what was said in that conversation to his father right before, hours beforehand. So that's your now evidentiary question. Was it relevant? Something the jury should have heard? Help them? Would it have been helpful for them to determine the reliability of the statements? The answer to that is yes. But then you have the Constitution question. Was the exclusion of defense evidence concerning the circumstances surrounding Richard Allen's statements, admissions, did that violate his right to present a defense, where his sole defense was, look, there's no physical evidence and my statements were unreliable. So that becomes both an evidentiary question and a constitutional question that still doesn't deal with the statements itself. Like, was it voluntary? It's just the reliability of it. So, Michael, we'd have both the 2 ways the courts could look at it there. 1, an abuse of discretion on the evidentiary side, and 2, was it so important that the jury understand was it so important to judging the reliability? For instance, that first conversation with his dad where he says, "Hey, I'm losing my shit here. I didn't do this, and if I say something else otherwise, don't believe me, don't listen to me, blah blah blah." Hours before he then says, "Hey, I think I did it." If the court finds that was so important to the jury understanding or determining reliability that it actually impeded on his ability to present a defense, then it becomes the constitutional question we were talking about earlier.
Yeah, the right to present a defense undermining the reliability of the statements. I don't think I've ever seen the right to present a defense directed at something as specific as that. I mean, I suppose it's the same, but it's not really different in kind from the right to present a defense by explaining the crime scene. We'll just have to see how it comes out. Yeah, I mean, they kept out the audio. I mean, it turned out there was audio of some of the
all of it. There was audio of all of the camcorder shit.
And why was that? I mean, why was the audio kept out?
I don't know.
I think she said it was hearsay.
Alapo had fucking lied at the safekeeping hearing in June? Like that, the warden of the prison literally was on the stand and unequivocally lied. He said, no, because I'll never forget it. I went home and I told Allie, I'm like, hey, like on those old camcorders that we used to walk around with, the old shit. I'm like, have you ever seen one that didn't have like a built-in microphone? Because this guy was on the stand sitting here saying that when they were filming Rick while he was in with his attorneys, that there was no sound, that they weren't recording sound. I don't remember that being an option in terms of, and we made a lot of home movies. So when I came to find out, and it didn't happen until when Rosie stood up and they were getting ready to play those videos. And Brad said, all right, I'm going to start it. And the judge asked the question. She said, is there sound? And he's like, yeah, there's sound. And she's like, no. You're not allowed to play the sound. And Brad's like, oh, okay, Max, and he had to have young Max go and create the video without the sound.
But did he object? I mean, I just don't know.
I can't remember if he said, I think her thing was probably it's hearsay, and I can't remember if he said it goes to the state of the mind of the defendant. And yeah, I think she sua sponte did that. It sounds
She
like
did.
right?
She did. And I don't remember. I mean, obviously we have the transcripts at this point. I don't remember if Brad objected either. I could tell you that the thrust of his argument with respect to getting that earlier recorded call to his mother and stepfather, Ken, was completeness doctrine argument.
Yeah, absolutely. Yeah, absolutely.
And it was a good argument. And I felt like, I was upset that she wasn't allowing it in because it's a continuation. It's a continuing story in terms of that particular morning.
Well, and there's not, I mean, presumably Gull hasn't seen the video, so she has no way of knowing that there's any statement in there that even might be offered for the truth of the statement.
Right.
And by the way, I mean, I obviously haven't seen the video. Can you hear people shouting at Rick?
No.
Taunting him on it?
We heard no audio from any of the videos that were
No,
shot.
but what I'm saying is there is audio. Does the audio, if people had heard it, would they have heard other inmates taunting Rick?
Oh, are you talking about the audio of his phone calls that we heard?
No, I'm talking about the audio of him
walking around
in the prison.
I have no idea. I mean, theoretically, yes.
Exactly.
I would assume so. Yeah, I mean, I would assume that that's exactly what you'd hear, right?
I don't know.
I don't know if there was audio for the in-cell camera.
What I'm saying is whatever's on there, it seems to me there was extremely little argument made about why the audio should come in and I'm really kind of curious. I mean, Indiana judges, I mean, Gull's been around too long. It's like generally Indiana judges think that anything said outside of a courtroom is hearsay for some reason.
Right. We talked about this on. Go ahead. Sorry.
But it's hilarious when you go back to the contempt hearing, right? And like all this hearsay, all this unauthenticated internet hearsay comes in. But you can't have the audio on Rick's prison video at the trial.
Yeah, I mean, you and I have discussed this, Michael, off pod and off camera. The concept of these, the issues relating to the confessions and, and I think ultimately it boils down to whether or not, there's an argument as to whether or not they were voluntary, and Brad had employed a pretty novel argument, because this wasn't a situation wherein, you had a guy in in some kind of interrogation room, and you're signing the light on him, and you got him up for 72 hours, and you're not allowing him to drink or eat. Like the torture that they employed was very different. And it just took months for it to take hold, and it really, that is another cumulative type argument in terms of the type of torture that they employed. And it's an unusual set of circumstances because it isn't supposed to happen to pretrial detainees or detainees for that matter. Right? So I don't know. I don't know, man. Like I don't know if that thing's gonna have legs at all. I mean, it should, but you and I have talked about whether or not we think that it will in terms of those confessions. And the one thing that I also want to kind of remind people is that the three judge panel doesn't care in terms about what the jury relied on because they don't know. Because they have to come up, when they're playing that kind of, mental gymnastics, and I'm talking about the judges, and they're like, okay, well, could this have impacted the jury's decision at the end of the day? It's like they don't have the background of what the jurors relied on. It's a strange exercise. You know what I mean? Because they're really, they don't know what the jury relied on. So, when they're sitting there trying to figure out what they think would have swayed them one way or another, or what could have potentially changed their verdict, I mean, they're having to guess. It's really a guessing game, So it's just I
Well,
don't know.
and that's why flipping the script, as it were, on the prejudice standard is so important, because if the state has to show it was harmless beyond a reasonable doubt, then the judges are thinking, really, the burden's on the state, and it's even more severe, it's even worse for the state for the Napui Glossop violation, if it was one, with Weber's van, because the standard for prejudice there is any reasonable possibility it could have affected the verdict.
Right.
Which makes a big difference.
Yeah.
And I mean, the van was a centerpiece. Any reasonable possibility that affected the verdict, it was the centerpiece of McClellan's closing.
Yeah. Sure was.
All right. So now issue 3, slightly different. Okay. The constitutionality of those statements made while Allen was gravely disabled in prolonged pretrial solitary confinement. So now this isn't about whether they're reliable and whether he was able to put on evidence that would have shown the jury that they were unreliable and would or could have resulted in the jury disregarding them because he was able to show it was unreliable. Now we're talking about the constitutionality of the statements themselves. And what would the argument be for that, Michael?
Well, so there are two versions of this, and I guess in one pleading somewhere, the word involuntary came up, but for the most part, I think the defense was pushing that his statements were coerced. And
by the conditions themselves, right?
Well, I don't know. I mean, all coerced confessions are involuntary, but not all involuntary confessions are coerced. I viewed it as more because he'd been drugged in solitary, because of the conditions, they were involuntary, because of his mental state. The problem is going to be, it used to be the voluntary. Let's just get over past coerced. I don't think. I mean, Stacy and Mark may make the argument they were coerced, and I'm happy to see it, and I'm sure it'll be good.
Well, I think the defense tried to argue that they set up these coercive these conditions in an attempt to drive him crazy, in an attempt to get a confession.
But
So
there's no evidence of that. I mean,
right.
there's just no evidence of that. I mean, could have gotten the evidence in a civil case if anybody had wanted to file one.
Yeah.
So the voluntariness, it used to be in Indiana until I think it was about 10 years ago, that the question of voluntariness of confessions actually went to the jury. There was a pattern instruction on it, and that's been changed. And now the question of voluntariness is for the judge. And if the judge finds it's voluntary, the jury doesn't. I mean, they get to decide for themselves, I suppose, what weight to give the confession. But the old instruction was, if you find it was involuntary, you don't consider it.
Which is why when you go back to number 2, how can they fairly decide what weight to give his incriminating statements if they don't know all the circumstances surrounding the statement?
I agree. I just don't know whether that's so they mentioned the constitutional claim. They don't mention the state law evidentiary claim. So yeah, we'll have to see how it shakes out.
Right. Michael and I are assuming they will include both claims when they write the actual brief. Like this is just kind of giving the court like a summary of these. There's a lot of issues here. So I'm assuming they're going to present both the evidentiary claim and the constitutional claim, but we shall see. Then 4 is pretty straightforward. The constitutionality of the search of Allen's home. So they filed a motion to suppress. The judge denied. What is the standard of review on whether the judge erred in not suppressing that evidence?
So here's the interesting thing. I don't know if they could, if it was error not to, and I haven't looked at the Fed cases on this and how they handle it. I'm guessing if they really want to draw things out, I'm guessing they could send it back to the trial court for a Franks hearing because they don't have the facts. They have the memo, but they don't have the testimony.
Right.
I mean, the Franks hearing would be to establish whether the search was constitutional. Yes, they had a suppression hearing, but that's not the Franks. So
we might assume it's built into this number 4. The constitutionality of the search of Allen's home is going to include her failure to hold a hearing to determine the constitutionality of the home. In such case, if they find the failure to hold a hearing was erroneous, they could just send it back to have that hearing. So
yeah, I think they could also send it back for hearings on the issues raised in the motion to correct errors.
Yeah.
Right. Then that's the next thing we were going to get to after we got past 5. But go ahead, babe. Sorry.
I mean, the way that it went down, and I'll never forget it because when I was driving out there, I was they had originally filed the motion to suppress, which they converted it. If you'll remember, it was early on. So they converted it to a motion to let bail, which they withdrew it completely. And I think Andy talked about it. And then they had it set for a motion to let bail, where I was excited. I'm like, okay, well, the state's gonna have to put something out here in terms of what they got evidentiary wise, because I'm not seeing it from the probable cause affidavit. And then by the time we got into court, that's when it turned into the safekeeping hearing. So both of those two things disappeared. I can honestly sit here and say I do not remember when did that motion to suppress happen? Because I think it turned into a Franks. Like when I think she said you need to do a Franks memo, if I remember correctly. Like I don't think that there ever was, because Andy had said something in court, and this is all straight from memory. And if people have read the transcripts, can help me out with it, I'd appreciate it. But I remember Andy saying, well, we're going to file a motion to suppress, or he did file, and she says, you need to file a Frank's for a Frank's hearing, a Frank's memo or a Frank's motion. And Andy's like, okay. And that's when he went back, and out of that statement from Goal, the Frank's memo was born. Because Andy was like, I had never written a Frank's memo, and I certainly had never written anything like this before. So I don't know. Like, was there actually a suppression hearing on the search? Does anybody?
No, well, and I don't think I mean, you were at the trial. Did they object to the introduction of the gun evidence because they shouldn't, because of the search?
I don't remember that they did, to be
So,
honest.
and what Michael's asking for all of you out there is, let's say pretrial, which happened here, they filed a motion trying to suppress evidence that was found in the house. The judge never really took it on a hearing. She didn't suppress it. When it goes to be introduced at trial, the defense should object. That's what you're saying, right, Michael? On the grounds that this was obtained by way of an illegal and unconstitutional search.
Yeah, and even if the judge, I mean, even if the judge ruled, you still have, before trial in Indiana, still they're thinking of changing the rule. But even in Indiana, if you get a pretrial ruling that, you know, we're not going to suppress the evidence, you still have to object at trial.
And we wouldn't necessarily know, because remember, all they do is say objection, and then she doesn't, right? Wasn't that the case there? Or now am I mixing up Karen Reed? Did they just,
Thank you, Salute.
what's Luthi say?
She said there was no motion to suppress hearing. She told them to file the Franks, which of course there was no hearing on, which is going back to what Michael was saying initially, you know, that there's this, they're kind of one and the same, in the sense that the argument was always going to be, because it's what you were saying, that they should have filed instead of the motion for the Franks motion, babe. Like
Right.
you felt that they should have taken a different route in terms of what they should have filed. And it's essentially what Michael was saying, because I mean, you have to have that Franks hearing, because you're essentially saying, look, Liggett came in here and was full of shit. He omitted all kinds of things, misrepresented things, and it was that the basis of that, you know, those statements that he made to the judge, in which he got the warrant, which they went in, they found these clothes that matched Bridge Guy. They found the memory box and the extra, they found Rick's gun, collected a whole bunch of phones and shit. All that shit came in. Yeah, I don't know. I don't know how that thing's going to play out. Hopefully, I mean, they put it in there as if a motion to suppress had been heard. I'm a little confused by that, but we'll see. We'll see.
All right. And then we have, sorry, I actually did a little search through the transcript for suppression. And then we just have an overarching other impactful erroneous evidentiary rulings. So that leaves, that could include any number of things. And then those impactful erroneous evidentiary rulings can also turn into constitutional issues, like Michael and I have been saying, how there's kind of 2 in 1 with a lot of these arguments. And also, as Michael pointed out earlier, can all roll in to a cumulative error. That when you take all of the errors, let's say you don't agree with me on the big ones, but you agree with me on a bunch of small ones, or when you take everything into effect, overall, this was not a fair trial.
Yep.
And then, as we were talking about before, they explained right in this very motion, because these issues involve an analysis of evidence that was proffered but excluded from trial, the record, which you could just consider the trial record, is much larger than just the evidence the jury was allowed to hear. And that's where we kind of started with this, that your trial record includes everything done at the trial level, whether or not it was actually admitted during trial for the jury to hear.
And Michael, in terms of structural error, can you talk about what that is?
And if we have any here,
And if you think that we have any here, yeah.
Well, I mean, so there's an argument they're not going to make. I'm reasonably certain, although it's a beautiful, beautiful case for it. I mean, I would be making, and I'm not saying they're wrong not to make it, but I would absolutely be making the biased judge argument. That would be structural error. That, I mean, she did so many things. We don't have to show prejudice. This was, I mean, ruling after erroneous ruling, doing things she had no power, literally no power to do.
I think it belongs in there strongly, Michael, very strongly.
Now, and you know, the rule in Indiana, and I'm sure it's pretty much the same everywhere, is you can't make out a case for judicial bias from a judge's orders. Well, this is the case that tests that.
No shit.
Well, no.
I mean, I agree.
Whatever you think of Gull removing them from Rick's defense, kicking him off, she literally had no power to tell them to stop working on the case in the week between, you know, when the leak came out and when she was having the hearing.
The ambush.
Well, speaking of structural error, if you're not going to include that as part of a judicial bias thing, so there is state interference with counsel. State interference with counsel says at least one case from the Court of Appeals has to come from a court order. I think that's wrong, but boy, have we got a court order. The court ordered them to stop working on the case. That's structural error. You don't have to show prejudice.
But Michael, don't you think that error was rectified when they were put back on the case?
No, because the whole point of structural error is you can't tell. You got to go back to square one, because you don't get into looking at what would have happened, what could have happened, that it just altered the arc of the case in some way. And this is what Chronic says, it is not worth the cost of trying to figure out the effect of the error.
But, and I understand it in I understand Chronic, but the difference here is they don't have to guess. They don't have to wonder, because they were actually put back on. And then
They
the
were
case
actually
was
put
finished.
back on, but they were faced with a contempt frigging trial for 3 months, which they might not have been if they hadn't been removed. They were going to move for a speedy trial.
Right. Rick Allen's speedy rights were just destroyed by them being removed.
I mean, if they'd had the week between, they might have filed for the speedy trial before she removed them.
They claimed that they were going to. I mean,
yeah, well, that's fine. But this is what, yeah.
But nothing that can be done now can rectify any of that, because all of those things happened. So in your typical situation where they're saying you were denied your right to counsel of choice, or you were denied your right of counsel, and we don't have to guess at how it would be different, doesn't matter. We're going to send it back. You're going to do it again with the right damn lawyers. That's where I struggle with that one, because it's like, you can't say, well, if he would have had that 1 week, he would have done something different. Well, you can't put them back in time where the state's not as prepared as they were in that 1 week and say, let's do it again, so that the state's, because everything has changed.
All you can do is reverse it and say, you got to do it over. You're absolutely right. But that's, and maybe it shouldn't be the rule, but state interference with counsel is an immediate reversal. You don't look at what happened. And then we get to the Chronic thing, and you know, there are problems with that, but you know, Rick didn't have a lawyer at this thing. And yes, there's a problem with the relief. You can't put him back in the position that he would have been in had he not been moved to Westville without a lawyer. And I don't know what you do about that, but structural error is error. You know, Sullivan v. Louisiana, it's error where you just don't look at any effect on the case is just, we're not going to look at this. It was wrong. We're done. We
Redo.
don't know.
Right.
Right. So
And
where we talked before about how, well, in some situations, the defendant has to show, he has a burden to show that he was prejudiced and explain to the court how he was prejudiced by this. In the other situation, if it's a constitutional error, we discussed how the state has the burden to show that he was not prejudiced beyond a reasonable doubt. In a structural error situation, no one shows anything. They don't look past it. They good you this thing happened, do it again. Period. The end. End of story. And I'm just thinking here, because of the way the procedural stuff that happened, that this would be the time where the court says, well, wait a minute, this falls outside the typical structural error because of the fact that they were put back on. And
I don't think and you're doing the thing that you're not supposed to do with structural error, and that is look at what happened later.
Right. The error was because I mean, like, if they were able to do that, babe, then I would be arguing, okay, well, because the reality is they are off the case for 3 months. The reality is when they got back on the case that they had to get all the discovery again and essentially as if they were starting from scratch. You know, in the same time, they're then filing a motion for the speedy.
well, I guess if the argument is that they were ill prepared because of it.
Exactly. That is the argument.
I know you don't look at why, Michael. I hear you. You never get to that point. But this is an unusual situation where I'm saying I get it with chronic. I get it with you're denied your right to counsel of choice or denied your right to counsel. And they say, no, he was denied his right to counsel of choice. Send it back. Do it again.
No, this is state interference with counsel, which actually, strangely enough, is in Strickland.
All right. Well, state interference with counsel. Well, we don't know if they'll make it or if.
Yeah,
it would play out.
I have no idea. I don't know whether they're going to argue chronic. I don't know whether they're going to argue the Van and Napoli. There's nothing in this pleading, the belated motion.
Yeah,
the tip art, right? We've got that.
There's nothing in there indicating they're going to.
They're not limited by this, guys. This is just them,
Oh no, but
right. But there's no tea leaves for us to read about that.
Yeah, I mean, we're it's what, 9 o'clock, just about 9 o'clock your time. I mean, so let's talk about that. So once they get it filed,
Michael, you'll be able to see it on the Indiana docket as soon as it's filed, right? Oh no, it has to be accepted. So
yeah. So Micah, so it's
the filing, guys, the filing has to be accepted by a human being in the morning is all I mean.
Yeah, probably. So yeah, the appellate clerks look things over and there's a multi-volume appendix that has to be approved. There's and maybe that's already been done, who knows. And if the brief is defected for some reason, and it can be noticed if one of the appellate clerks says, something wrong with this.
You're missing your whatever.
Yeah, you didn't name the actual. I mean, I got a defect once because I just said it was served on the Attorney General and I didn't name the Attorney General.
Now, what happens if, and we know that some of the things that are contained in the Franks are sealed, some of the exhibits. I mean, is the appellate court going to have to go through and redact that before they release it to the public?
No. So what will happen is there will be public versions of the appendix filed. There will be a public version of the appendix filed, and there will be a confidential version. And the confidential version will have the redacted, will have blank pages that have been.
Or the public version will have that one.
I'm sorry, the public version will have the blank pages. Yeah.
Right. Okay.
And
so,
I think that's really already been done.
Okay, good. I mean, I'm anxious.
I had a case on appeal where there were things admitted at trial that were admitted under seal. And so there was basically an under seal portion of the record that the the appellate court got and the regular record that the appellate court got. And I could talk about the stuff under seal. I could describe it. I just couldn't attach it.
Yeah, right.
So there should not be any redactions to the body of the brief. It would just be the appendix and the list, right, Michael?
Yeah. Yeah, I mean, the appendix will have a public and a non-public access. They'll have two versions, public, non-public access. The brief will talk about everything. The pagination will be the same, so they just have to refer to the appendix page X, and the Court of Appeals will know it's
Right, they'll have it.
yeah, they'll have it.
All right. Well, I mean,
Well, let's go over because I think some people have questions for Michael too. So Jessica has been a member 11 months. Says I'm not a subscriber and I cannot comment. Sorry about that, Jessica. I don't know what's going on. Hopefully that got fixed.
fixed. She sent a super later.
Belly Mayday and Critical True Crime. What do they get, babe?
Oh, family hug.
Thanks. Thanks, guys. Thank you. All right. Jason McClellan says, when someone does something like that,
you made it way too close to McClelland.
Oh, McClellan.
Yeah.
When someone does something like this, like Gacy, there are usually horror stories that come out about the accused. He has a record, etc. Like the Bondi shooting. Those two were investigated by ASIO for terrorism in 2019. So, and often you see that in your practice as well, Michael, that like when someone does something this bad, there's usually some sort of background that correlates.
Yeah. I mean, it's not that, I mean, people do start committing crimes at some time, maybe later in life. It's fairly rare.
Right.
Most people don't start off
with a double homicide.
Right.
Double homicide in broad daylight with a knife.
Just shy of 50.
Yeah.
And that's why
After
the
a heart attack,
circumstances, but that's why the description of the crime scene is so important here. That's their issue number one, including alternative explanation for the scene, because that stuff speaks to this guy's not that guy. Whoever did this these ruins or whatever were important to them for whatever reason. They don't have to be, like these traditions were something important to them that they had knowledge of, that they were even aware of. And there's no evidence that this guy had any information, that Richard Allen knew any of that stuff. So that's why, for exactly your point, Jason, why being able to talk about the underlying scene and the reliability of the statements are so important. Amanda Liv's mom, member for 12 months. Thank you for your generosity. 1 year, baby.
Yes.
Anyone had eyes on Ricky lately? I don't think we know.
We know he's in Oklahoma. I think appellate counsel went out to see him as well.
Julie has been a member for 10 months. Merry Christmas, fam. We need a local meetup in 2026.
Agreed.
All right. So Travis asks, when is an amicus allowed in COA?
Anytime. I mean, in what kind of case or what's the timing?
I think he's just wondering, like in a court of appeals, because I see them often in a Supreme Court, not as often in appellate courts.
No, you can file it in the Court of Appeals or in the Supreme Court.
And they just file a motion seeking permission to file an amicus brief, right?
I'm not sure. As long as you have permission from the party you're filing an alignment with, I don't think you need permission.
All right. And Jessica says, you three are utterly priceless to society. Much gratitude. Well, we appreciate that. Thank you.
Thank you.
Canine Kelvis says, I look forward to to discussions of this case. I just need to be honest. Bob, please don't be so hard on Allie and guests. I enjoy hearing from everyone. It makes me really uncomfortable how they're treated. But in all fairness, Bob did have, and I think it worked out for the best that we started with the nuts and bolts
Yeah, I
before
think
we
she posted that like she was
early.
late watching.
Yeah,
So
7. Yeah.
I don't
sorry, not sorry. I had a way that we were going to do it.
feel
So
treated by Bob at all. I mean,
thanks, Michael.
Me neither.
I
Dr.
just
Vonda.
wanted the people to understand how the appellate process works.
Yeah, you were right. You were right.
Thank you.
Dr. Vonda, well, thank you, Dr. Vonda. And T Dubba says, are Gull/McClelland shitting themselves right now? Well, who
probably
knows? Right, probably
Yeah.
not, unfortunately.
Yeah.
But thank you for your continued support, T Dubba.
I don't think Gull's thinking about this at all.
Well, she should be if she gets reversed, but maybe she
Well,
doesn't
I
care.
mean, she'll think about it then. She might not care. Well, I mean, the reality, and that's one other thing. Let's think positively. If it gets reversed and remanded, I mean, she's still, even though she was a special judge, appointed special judge, I mean, she's still on the case unless the appellate court says, hey, you
Which you're not going to do if they're not asked.
yeah, I mean,
And
right.
if they don't put all that bias stuff in there, they might not see a reason to do it.
Yeah, it's like, man, I don't know. Like,
And-
she never, because at the Supreme Court hearing, I mean, they just didn't argue anything orally about getting her off. I mean, like, you have to pick and choose your poison in terms of what you're going to argue. And Lehman did a great job, but like, they never even mentioned like anything about her bias and pulling her off the case. It wasn't even uttered. So, they were obviously just relying on the papers, and it didn't get addressed. I mean, they addressed it in their opinion.
Yeah.
Like, hey, cut the shit. Your docket's a mess. Like, flesh out your orders a little bit. It's
so what is this?
I don't know.
Jadzia Docs? Is that how you'd say that?
Yeah. I don't know. What do you think, Michael?
Well, thanks for your continued support. She says, great, or he, great conversation. Merry Christmas, everyone. Well, Merry Christmas to you.
That's Yajada.
There we go. Good job.
Yeah.
Polish.
All right, Michael, you've anything else you want to say, or?
Wait, there was one last one. Eads
Oh.
here. I just want to know what Magic Michael did to soup up his Wi-Fi, your Wi-Fi. How my middle-aged friends and I pronounce Wi-Fi. It's a love. The secret was what, Michael?
I hooked up the Ethernet connection to.
Yeah, baby. Yeah.
Good
I was
work.
so
Good
proud
work.
of him. He's like, I'm gonna hook up to the Ethernet. I'm like, and you sounded fabulous and you looked fabulous. So that was
Yeah, people
definitely a great move.
really enjoyed actually seeing you today.
Yeah,
so.
yeah, it's nice to be able to see you. I mean, I've seen you in real life, so all right, man, you're awesome.
And say hello to your wonderful wife from us. It was a pleasure
Yes.
meeting her as well.
Yes, and we'll be talking tomorrow. We'll be talking tomorrow.
I'm guessing.
Yeah. Well, we appreciate you as always, and your profound intelligence and great knowledge of the law. It's much appreciated over here, my friend.
Always fun with you all, and thank you so much for the opportunity.
All right, talk to you
Thanks,
soon.
Michael. Bye.
All right, guys.
All right,
people.
you guys are amazing. Thank you.
Hopefully you found this
hopefully it was
educational.
informative. Hopefully, I really, what I was trying to avoid is when Allie and I start going through the brief with you guys. And the plan is, I think Andy, if it gets dropped tomorrow, Baldwin wants to jump on with us. I don't know how we'll do it. Like, Michael also wants to go through it with us. Maybe we split it, because it's going to be lengthy. Maybe we split it into a few lives, have Michael, have Andy, but we'll figure that out kind of logistically, how we're going to do that. But tomorrow's the big day. Tomorrow's the big day. So I expect to see a lot of, I'm putting you guys on it. I want to see your Twitter feeds just hammering Richard Allen in terms of the appeals out. We got to get more eyes on this case. It's frustrating. We got a good amount of the free Karen readers over here, but we need more. This case is just a shocking case. It should really shock your conscience. And I think that hopefully the brief lays it out in such a way that, they argue it so that you're feeling it just exactly how fucked up this was. We've always called this Delphi unhinged for a reason, because it was. So I know you do. Well, Sleuthy, you're one of the good ones. You know that. So we love you guys. Mods, thank you so much. Manny, if you're out there, love you. Hope you're feeling better. Tracy, adore you. Thank you for everything that you do every single day. You're an amazing human being. And to you guys, we adore you so much. Do us a favor, please make sure to like, share, and subscribe. If you're on Replay Crew, leave a comment. Get a conversation going over there. Get the thing into the algorithm. That helps get more people on the free Rick Allen movement.
Yes,
it's
and
like,
subscribe. It's free.
it is free. So we're so close to 60. Let's get there. Help us.
Help
All right,
us.
y'all. We love you so much, because without you, I'd just be an old man.
Sitting around talking to his wife.
Boo.